I salute you all. Thanks for being on, and hope you are all doing okay. Just simply subscribe to the channel, like the video, comment where you feel that you haven't understood or you haven't grasped the concept. So basically today we are under land law. And the topic that we are going to emphasize about more so it is the topic of what? The topic of legal and equitable interests in land. The legal and equitable interests in land. Basically, those are the two principles in land law that we are going to look at, and they are key, they are vital. And basically what you have to know is that we only have two interests. There are only two interests in land. You have the legal interest and the equitable interest. Those are the only interests that we have in a land. But however, we are going to start with the equitable interests, the categories. Where is equitable interest portrayed? That's what we are going to start from. Basically, what you have to know about an equitable interest, let me differentiate it from unlegal. Basically, an equitable interest in land is that you don't have the legal title to the property, but you have an interest to the property. So that's the difference that I can give you. That's about equitable. You don't have the title to the property, but you have an interest, as we are going to see the different scenarios. So basically, I will start with the unregistered lease. You get the unregistered lease. It is not witnessed in law, but however, it is an equitable interest. Equitable interest comes from the word equity, fairness. It comes to bring fairness. You get? So it comes from the word equity. So unregistered lease is under unequitable interests. What do I mean? Actually, we shall relate to section 54 of the Registration of Titles Act, where it says that any instrument that is not registered does not take effect. You understand? So basically here it gives you in mind that unregistered lease is not registered, so it is not under the categories of something that is registered as per section 54 of the Registrations of the Titles Act. But however, equity comes in to say that however much the lease is not registered, but nevertheless it is a recognized lease by law. You understand? Under equity. So basically, I'll give there is a good case about that scenario. The case of Souza Figueiredo, and Company Limited versus Moorings Hotel. Actually, that case, it was whereby a person had contracted a lease, but however the lease was unregistered and it was beyond 3 years, and there was an excess of even 3 months. So he had contracted a lease. So before even the lease agreement had expired, he vacated the premises before even completion of the lease. But however, they didn't register the lease. So the owner of the land sued because he left the land with some errors. So the owner of the land sued for the rent. But however, the other one said that the lease was unregistered following section 54. So he couldn't pay He couldn't pay rent. So as a result, this person went to court. So court held that given the fact that there's no any provision of law that renders such instrument as ineffectual, you understand, as ineffectual, or as contracts between parties not effective or nothing, see, when they are unregistered. What do I mean? If the law doesn't prohibit or doesn't prohibit that unregistered lease is prohibited by law, or it is not recognized by law, why then do we declare it void? You understand? So if it was in operation for more than a period of 3 years, the intention was to make it a lease, a valid lease. You understand? So to confer with the principles of equity, it was held that the respondent was entitled to what? The person was entitled to rent. You understand? The owner of the land was entitled to rent fee, whereby the appellant, it was even an appeal case, where the appellant, for him, since the latter had taken possession as a tenant at will, basically he was supposed to pay rent. You get? So put that in mind about unregistered lease. Yes, then we also have what they call, or what I may call, an execution of a purchase agreement. What do I mean by an execution of a purchase agreement? This is where you basically, when you buy something, but the possession or the ownership of that thing is still under the seller. You understand? So basically, there you have the equitable interest in the commodity because you haven't attained what? Possession of it. When you relate to the case of Chan versus Christendon, that case portrays that element very well. Then still under equitable, we have what they call part performance of the purchase agreement. What do we mean by the part performance of the purchase agreement? Is that you haven't fulfilled all the obligations of the agreement. If it is the sales agreement, you are just in its part performance. And the good case that portrays it, that brought it, there is a case of John Katarinkawe versus William Katweirim. That is a good case whereby I'll give the holding, whereby the court held that, or the court had to say that a contract for sale of land is not perfect. Is not perfect until an effective transfer of title has been made. But failure to do so doesn't affect the contract until the land is transferred to the other persons. What do I mean? If you are in a contract, if there is a transfer of land, the buyer and the contract acquires only unequitable interests until the land is fully transferred to him or her, or until his names are registered on the certificate of titles. So basically, note that in mind. That is the case of John Katarinkawe versus William Katweirim. So that is a good case. And you can also add a case of Brother Moses versus Abdul Salam and others. That is also a good case that backs up the latter. So that's one of the elements of equitable interest in land. So as we go on, there is also taking possession of the land by the purchaser. Taking possession of land by the purchaser here comes in a way that whereby the purchaser hasn't finished the part payment of the land, but however the seller has given him to take possession. Here you find that the proprietor if he allows the registered proprietor, if allows the purchaser to take possession, which means the purchase price to take physical possession and the occupation of land, they are two different. To take physical possession and the occupation of land is that, what do I mean is that when you take physical possession, doesn't give you the occupation of the land. However, you take occupation when you have finished the whole payment. But here, the physical possession, you take it and you be having that equitable interest on land. And here, the seller or registered proprietor cannot evict you. The only remedy that he or she has is to sue for payment of the price, the remaining price of land. Basically, if you are paid bad performance, the registered proprietor cannot evict you on the land. So put that in mind. Even if you are paid half, which means he can also only sue for the half balance, but he cannot evict you from the land because of failure to fulfill the payment. So basically, bear that in mind. There's a case of the Das Kamugisha versus John Jagenda of 2002. Actually, this case portrays or brings out the vivid explanation of taking possession by the purchase by the purchase of land. Basically, here court held that the defendant took possession of the suit promises to the plaintiff. In the absence of the full payment of the purchase price, the defendant would have been entitled to a change or a lien on the suit, as well as the right to retain possession. Therefore, until payment is is full. However, he did not voluntarily grant the plaintiff vacant possession of the suit premises, thus foregoing the latter right. What do I mean is that he forego the latter right, which was to take possession until fulfillment was made. But however, he was supposed to sue for the payment. You get? So basically bear that in mind, or not that in mind. Then there is also, we have under category of equitable interest, we have what they call tenants of occupancy. Tenants of occupancy. Here we shall relate to Article 237, Clause 8 and 9 of the Constitution of the Republic of Uganda. They talk about the Bonafide and the Lawful occupancy. So I will start with, these are also equitable. They have equitable interest in land. Remember that a lawful and the bona fide occupants, these are the tenants by occupancy. They don't have a title. They don't have a title to the land, but they own an equitable interest to the land. So basically, I'll start with the bona fide. The bona fide, we shall see Section 1E of the Land Act. I'll see even Section 29, subsection 2, A and B of the Land Act. Even Section 3, subsection 3, A, B, C, among others. I shall read that section verbatively. Here we realize that it's talking about bona fide occupants, and they are also invested in the case of Sirwada versus Kasozi and another. That is a good case about bona fide occupants. Here we realize that the bona fide occupants, when we read verbatively about who is a bona fide occupant, this is a person who has settled on land before coming force of the 1995 Constitution. You understand? For a period of 12 years. Here for a bona fide, you must have unchallenged. You understand? Note that word, unchallenged. Unchallenged is that you are not inconvenienced by the registered proprietor until the lapse of 12 years. Here basically what they are meaning is that you have stayed on the land for a period of 12 years before the coming in force of the Constitution. Then basically what they are meaning is that the Constitution must come into force when you have already lived on the land for a period of 12 years and above. Basically, note that in mind. And also another category of a bona fide occupants is someone who has been we are still before the coming into force of the Constitution. So basically bear that in mind. And we see that a person who has been settled by the government on that land, you understand, still we are under when you read section 29, subsection 2, someone who has been settled by government on that land, but the government must have compensated the registered proprietor of that piece of land. You understand? So basically bear that in mind. And when you go further, we have two tenants of occupants. That was bona fide. Then when you go to tenants to lawful occupants, they are also brought under Article 237, Clause 8 and 9 of the Constitution, and also Section 29, subsection 1, A, B, and C. Follow. So basically, lawful occupants, what I can tell you is that the good case, before even I go to further explanation, the good case, we have the case of Kampala District Land Board and Chemical Distributors versus the National Housing and Construction the National Housing and Construction Corporation of 2004. Actually, here the Supreme Court held that the sitting tenants should be given a priority to a leased land if it is being leased. If the land is being leased, the occupants that are sitting on it must be taken as a priority before the land is leased. So put that in mind. So basically, lawful occupants, these are the people that settled on land following the Busuru and the Mvujulu, although they are repealed. But if you know the background of the tenure systems or the background of tenancy system in Uganda, this is a good area. Any person that settled on land following the Usulu and the Vuju laws of 1928, anyone that settled on land following the Toro land lord and the tenant law of 1937, anyone that settled on the land following the Ankole landlord and the tenant law of 1937, those are lawful occupants. But however, those laws were repealed. But anyone that settled on land following those laws by then is what? Is a lawful occupant. And anyone that enters on land with consent of the registered proprietor of the landowner or by purchase. What do you mean by purchase? Buying land through a purchase what? Agreement is a lawful what? Is a lawful, what do I mean? Is a lawful what? Occupant. Even this customary, the customary tenants that settled on land before it being leased. You understand? Before it being leased, they are also lawful what? Occupants. What do I mean? If a land is being leased, the people that settled on it by that time. Remember that time when land was for the government, they provided for leases. Leases. So if a lease was given, but however when it was given, there were customary tenants on it. Those customary tenants were regarded as lawful occupants. So basically bear in mind. However, we shall look at the security of the tenants by occupants in another discussion. So basically note that, you understand, these people have a security of tenure. Though they are not registered, but they have an equitable interest in the what? In land. So put that in mind. Refer also to section 31, 33, 34, 35, among others of the Land Amendment Act. You understand? The Land Amendment Act. Hope I'm clear. Refer them to understand more about those tenants by occupants. So basically we shall go to another category under equitable interest. We have what they call family land. And basically what you have to bear in mind about family land, we are all having families. However much I come from a family, but I owe what? An equitable interest in that family land. Although my name is not on title, but that's what they call family land. And we shall refer to section 39 of the Land Act. Understand? Section 39 of the Land Act shows what family land is. It has subsections, but for me I'll try to explain what they mean by family land. What you have to know that any land that is situated for ordinary residence of a family, it is family land. They say that any land that is situated for the family residency and is from the family, it's where the family sustains what? Sustains or deprives sustenance, it is family land. Let me explain this point. If you are the father and you bought land somewhere, but that land, it has your names, it doesn't have the names of the wife, and accidentally or fortunately or unfortunately, you tell that to the wife, you know that the land that we are having in Chengera, that land is where we gain sustenance, rentals, what and what. It automatically turns to become family land. You understand? So long as that land, you declare to the wife that's where you are gaining what? Sustenance. Or that's where you are gaining sustenance for the betterment of the family. It automatically becomes family land, even though the land title is in your names only. So basically that's the point. And also, any land which the family freely and voluntarily agrees shall be treated as a family what? Shall be treated to quality under what? Shall be treated as family land. And where the family land is treated according to the norms, customs, tradition, or religions of the family, it is also referred as family land. You get? And also, basically, you refer to Section 38A of the Land Amendment Act of 2004. That one says that it comes that in categories of sale, lease, resale of land, the spouse's consent is key. You understand? There must be consent of the spouse. So that is what we call family land. So put that in mind. The good case, there is a case of Brother Moses versus Abdul Salam and others. That is a good case about what? Family land. So put that in mind. Basically, put that in land, whereby they say that under that case, they invest that the respect of the registered land, the proprietor rights to the parcel or to the parcel of land are vested in the householder. You understand? With the rights of occupancy guaranteed and protected by the laws for the unregistered what? Spouse, for their joint tenancy, occupancy, use and enjoyment. We all know what a joint tenancy or joint occupancy they are trying to mean. And basically these laws of family property, they are brought in for the better enjoyment and the use of the land as a family. So put that in mind, or bear that in what? In mind. Then we also have what they call the beneficiaries of undisputed what? Beneficiaries of undisputed land. What do I mean by beneficiaries of undisputed land? Basically here what they're trying to mean is that the good example is that whereby a father dies and leaves land for the children. That moment before land is undisputed, it is the beneficiaries are having the equitable interest in that land. The beneficiaries, these are the surviving children, spouse, among others. You get? Basically, this category works in whereby the owner of the land or the registered proprietor has died, whether testate or intestate. You understand? Then his beneficiaries to the property are entitled to the share to the property. Their equitable interest before that property is being disputed, they have the equitable what? Interests. They have the equitable interest in that one, in that land. So put that in mind or bear that as a key point. There is a case of Anecho Haruna Musa versus Walibunua. That is a case that it related to section 180 of the Succession Act, whereby the administrator of the deceased or the administrator of a deceased person is his or her legal representative for all the purposes of the property. The property is first invested in the administrator or the legal representative of the deceased before it is being disputed. So the beneficiary to the property, they gain an equitable interest to that property. They can do anything to that property since they have that equitable interests before land is being what? It's being disputed. You get? So basically that's the point, and that's the point that I'm trying to drive home. So basically that is the brief about equitable interest in land. So we shall go to what they call a legal interest in land, which is the torrent system. So basically this topic you shall gain it more under land law 2. This is where this topic is more elaborated, which is the torrent system or the legal interest in land. Basically what you have to know about legal interest or the torrent system is that it is a system of establishing a title to the real estate. Establishing a title to the real estate in which the claimant first acquires or a person acquires an abstract of title of certificate following section as evidence of what? Ownership. That is section 59 of the Registration of Titles Act, which says that a certificate to title is a conclusive evidence of what? Ownership. Section 59 of the Registration of Titles Act. They move hand in hand with section 54 that no instrument shall take effect unless registered. Understand? So any registered instrument following the provision of section 54 of the RTA is under legal what? Is under the legal interests of land. You get? The good case to refer to is the case of Ndigejerawala versus Kizito and Kabula Mwana. So of 1953, 1953. So basically, under this case, realized that Chizito was the registered proprietor of a certain piece of land, was the registered proprietor. So he agreed to sell the land to Kabulwa Mwana, the second respondent. You understand? Then he also underwritten this. It was under sales agreement or a written agreement. Then after 2 days, Chizito again sold the land to Ndigejerawala. You understand? And the Ndigejerawala was the appellant, the one that reported. So this appellant went to the register of titles with the document to transfer his title to his names, only to realize, even before, the second respondent, who was Kabulwa Mana, also went to the registrar to transfer the title into what? His names. Now, actually, none of the buyers got title because all the documents presented were not registered were not what? In a registrable state, because all of them had the same piece of land, but they wanted title. You understand? So there was a kind of fraud. And here court stated that, or speculated that, no document or instrument can be registered unless it fulfills the requirements of something that can be what? Registrable. Here court held that none of the buyers got the title, since none of the documents relied upon the statutory requirement of the ordinance following section 54 of the RTA. You understand? But however, the first or the second respondent, who was Kabulwa Mana, was given a remedy of specific performance. Then Ndegejera was given damages. What do I mean is that here basically court held that Chizito remained the registered proprietor, was the owner, and these were not the owners. But however, Kabulwa Mana has given specific performance. Actually, Chizito was compelled to sell the land to Kabulwa Mana, because where two equities are equal, the first in place prevails. That was the maxim that was brought. Since Kabulwa Mana was the first to gain interest in land, basically he was given specific performance so that he acquires the title to land. Then Ndegejera was given damages. They told Chizito to pay him back his money. So basically note that and put that in mind. And there's also a category of what? There's a category of mortgage or mortgage as an instrument. Why do I mean by mortgage or an instrument? You get here basically what I'm trying to mean is that a mortgage unregistered, a mortgage that is registered becomes effect and it becomes legal. You get it becomes legal. Remember that if you are mortgaging land, this land becomes what? That mortgage becomes legal because it is registered on the title. You get, when you read the case of Bank of Africa, Uganda versus Ganyo na Edina and another. So put that in mind, where they say that the registration of a mortgage interest is reflected, if it is reflected on the title deed, is conclusive proof and indivisible against the other persons following section 59 of the RTA. You get, it protects it. Section 59, they say that it not only protects the registered proprietor, but also an instrument affecting or protecting an estate or an interest in land which is registered, such as what? A mortgage. So put that in mind. Then we also have what they call a beneficial caveat. What do we mean by a beneficial caveat? Following section 139 of the RTA, or the Registration of Titles Act, gives powers to the beneficiary, anyone that is a beneficiary to the land, to lodge a caveat to protect his or her interests. You understand? So basically note that in mind. A caveat is like you put a caveat. When it's put, you cannot sell, you cannot lease. Caveat is like a barrier. It is like an injunction. That's the good meaning, clear explanation. It's like an injunction. It is like a restraint from any further business on that piece of land. So put that in mind. I know Mugisha Dorin versus Sava, Michael David Chaze. That is a good case about a beneficial what? Caveat. So put that in mind. Basically, that's what I can elaborate about the legal what? The legal or the clearing system. But more it will come in landlord too. Basically, it will come in landlord too. Put that in mind. And basically, we have what they call the priorities of legal and equitable interest, or the competing legal and equitable interests. When two legal interests are competing, the first one in place prevails. The first prevails. You understand? The first in place prevails. When you read section 48 of the RTA, the first in place what prevails. Then there is also where legal and later equitable, still that one, the legal prevails because it is the first one, and the legal carries more weight than the equitable. The first one prevails following section 59 of the RTA, which guarantees that a title deals with the conclusive evidence of what? Of ownership. Then there is also where I have two equities, competing equity, where two equities are competing. The first equity prevails. You have seen the case of Ndegejera versus Chizitan Kabura Mwan. The first one prevails. Then there is also where competing equitable interest, then later legal. Here we shall use the section 59 that a title is conclusive evidence of ownership unless it was obtained under fraud or anything that is unauthorized by law. But there the legal prevails. You get the legal one what prevails, unless even the what you have to know is that the prior equity in land can only be defeated by a subsequent what? Bonafide purchaser for value without notice of the prior interest, than his estate prevails and equities are what? Are equal. Basically here the legal or the legal interest in land must make sure that he attained what? Ownership without notice, was a bona fide purchaser without notice, that there existed what? Some equitable interest in land. So if there existed, then basically the sitting interest on the land will be taken as a what? As a priority. Put that in mind. There is a case of Peter C. Katwebers and another versus Growth in East African what? Fund and others. Basically, this case brought out the principle or the priority at common law of the competing interest. It gives out that rule or the general rule that between the competing interests, the first in place prevails. Basically, that's what is brought under this what? This